So, anybody here advertising about this state or this state? About, yeah, forming an LLC. Wyoming, Delaware, right?
But you still have to file in California for pleasure to doing business there if you visit it, isn't it?
Very good.
Every year.
Yep. There's a weather tax, ladies and gentlemen. And the Franchise Tax Board is here. That's a little bit later in the slides. But they are hot and heavy on exactly that. And how do they get the information? Just as a practical matter, how do they get the information? It's on the federal return, right? What's California require you to do? Attach a copy. It's not hard for them to find out that you have an entity outside the state of California. Some quick rules. The IRS says there's no such thing as an LLC. Everyone knows that, right? Right?
Right.
Okay. It says it's either a single member, which is a pass-through, which means you're filing a Schedule E. If you don't do anything, what's the default? Partnership. You have to file special documents to have it treated as though it's a corporation. If it's a corporation, then you can file additional documents to have a sub-S tax rate. Everybody understand that? I know, it's like...
Yeah, it is like.
It is one of those things. But again, to give you knowledge, it's a little out of context, but I'm going to take it out of context. The Franchise Tax Board, in the past, there's a 10% penalty for late filing of the franchise fee. For an LLC, how much is that? I only ask strict questions. What's the answer? It depends. If gross receipts are $250,000 or less, it's $800. If gross receipts are from $250,000 to $500,000, how much is it?
$2,500.
Not quite. It's $800 plus $900. The very end slide goes through all the rates. So be aware of that. The Franchise Tax Board has said, if it's a partnership, I'm not sure how much time I have left. Okay. The Franchise Tax Board has said, if it's taxed as a partnership, and even if you have a property management in another state, and even if the bank accounts are in the other state, and even if you don't get any phone calls, any emails, you go 4 times a year to that state to transact business. What do you think the Franchise Tax Board says? You owe California gross receipt taxes because the possibility of managing is sufficient connection with the state of California for the state of California to tax you. Personally, I think it's unconstitutional. But California has a history of that. Anybody remember that California was taxing retirement plans? Wherever you move to, you earned it in California, we get to tax you. What stopped them? Supreme Court case saying no. And that's what's going to take this.
Is anyone challenging it yet?
No. Can you afford $5 to $10 million to take it to the Supreme Court? I can't.
Not yet.
No.
Are those thresholds an aggregate of your entities or per?
It's per entity. And if you have a Nevada series LLC, the Franchise Tax Board says each series is a separate entity. So the real problem is what happens if you've had an LLC for 15 or 20 years in another state you've never reported to here. What do you do?
Kill it.
Not speaking as an attorney, and because we're on tape, I will repeat your answer. You kill it, and probably would form another one, and then report it. But again, you have to figure out what you're going to do. But they are coming after it. Why do I have a slide for signs?
Right off your car?
Symbolism of shedding your clothes.
Yeah, do you have a company car with a logo on it? Where's that company car not supposed to be? Picking up children from soccer practice, picking them up from school, going to the grocery store, going to the dry cleaners.
That was all a part of advertising.
Because you're what? Personal use. So if you have a company car, talk to the gentleman in the back. You actually need a separate rider on your policy to cover the company car when you're on personal use. Additionally, if there's a lawsuit against your company and they have proof that you weren't treating it as a business entity, what can they do? Pierce the corporate veil and go after your personal assets. If you start paying personal bills from that checking account, it's just a slippery slope, and you have to treat it as though it's a third party. I write a W-2, I write a 1099, I pay my personal bills with a different account. If I put money in, there's a promissory note from the company. The company pays me back with interest. You treat it as though it's a third party, because if you don't, the courts won't. And that's the problem with signs. Charging order means you stand in the shoes of the individual. Doesn't mean they have any management rights, doesn't mean they have any voting rights. They simply have the right to get money when it comes out. Again, assuming you have the right operating agreement.
So it has nothing to do with asset protection.
It has absolutely everything to do with asset protection. If there is no profit, how much gets paid out to the owners? Nothing. They stand in the shoe as an owner. No management responsibilities. No right to say anything. That's why you want the charging order. Corporation, they can get the stock. Once they have the stock, there's certain statutory rights. That's why people use LLCs.
So how do we get a charging order?
You have to go through an entire lawsuit, get a piece of paper signed by a judge that says this person owes you $100,000. Then you apply to court to get a charging order against those membership units that that individual owns. Charging order is against you. You're being sued. You want to protect your assets. Because there's no guarantee of money coming out, and it can take a while, you can usually settle for less on the dollar. That's the goal of almost all asset preservation. So, just because you're in this great state, anybody have an LLC that was formed before 2014? And you knew all the rules changed January 1st, 2014. California adopted the Uniform LLC Act. There's some really strange provisions that are default provisions. Anybody here want a majority of the members to be able to throw you out as a manager? That's the default provision, unless the operating agreement says something different. If you find, and assuming it's not family, you have some other people with you, you have an absolute duty to give any offer to the LLC first. So if you find a really good real estate deal and you want to buy it in your own name, but you're part of an LLC, your duty now is a loyalty to the LLC. You have to offer it to the LLC first, unless it's changed by the operating agreement. There's just a multitude of things that changed in California as of January 1st, 2014, so you need to update your operating agreements. Welcome to California. Nothing's the same. So again, fiduciary duty has changed. These are all the duties that have changed. Voting requirements, consents, managers, those are all the things that have changed under the revised Uniform Liability Company Act. So if you thought you had everything taken care of, you no longer do. You need to go back and change your operating agreements. What's that statute also called?
Full Employment Act for attorneys.
And accountants, just like any tax bill, right? What's the real name? Full employment for attorneys and accountants, or tax preparers.